What's happening, everybody? It's Gavin Washington, aka Gav the Realtor, back with another episode of Real Estate with Gav. First off, I want to give a special shout out to our partners, SC Studios. That's where we're hosting that today. Shout out to Moses and his whole team. If you need any type of marketing, content creation, anything that has to do with videography, SC Studios is where you need to go. As you know, Real Estate with Gav isn't just about real estate, though. We are going to talk about different financial avenues, investing, and today I got a special friend with me, Miss Jamie Hill. Jamie and I went to high school together and even played soccer together when we were younger. So, Miss Jamie, tell us a little bit about what you do, and let's dive into that.
Sure. So my name is Jamie Hill, like Gavin said. I'm an estate planning attorney here in Martinsburg, West Virginia. I work at the law office of Heather Dern Myers. And so we help people plan their estates, whether that's drafting wills and trusts. We help people administer estates once somebody has passed away. And we also do asset protection if you have a loved one that's going into a nursing home. So I, like what Gavin said, I went to Martinsburg with him and happy to be back in the area.
Yeah, glad to have you back, because you were in Georgia for a while, right?
Yeah, so I went to Emory University for undergrad and stayed down there and worked as an accountant for a little while and went back to law school at Georgia State. And then made my way back up here during the pandemic.
We're glad to have you back. So I've dealt with this a little bit just because in real estate, from time to time, we get estate sales. And so I connected with you recently, so I was like, this would be perfect. You know, Jamie could kind of jump in on this and give us a little bit of background into wills, estate planning, all that good stuff. So what exactly is a will, and how do I go about setting one up?
So what I will first say is that what we talk about here today is not legal advice. You should still go and talk to an individual attorney about your individual estate plan.
Of course.
But now that is said, we can get into it.
Yes, ma'am.
So a will is a document that states where you want your assets to go when you die.
Okay.
So that's a very simplified version, and you can have a very simplified will, or it can be very detailed depending on what the situation is. But to create a will, it's generally best for you to do that with an attorney, because you go to a doctor for your medical needs, you want to go to an attorney for your legal needs. And so there are some requirements that you have to meet to create a will. And so the first is going to be, you have to be at least 18 years old.
Okay.
And again, this is all going to be what the West Virginia law is. If you're in a different state, it can vary.
Gotcha.
But you have to be 18 years old. You have to be legally competent, meaning you have to understand the document that you're signing.
Okay.
And what it's doing. And you also can't be under duress. Somebody can't be forcing you to sign this will to get them.
Okay. Are there any different types of wills?
There's, your will is your will, and so there can be a simple will, which is just my assets go here.
Mm-hmm.
There can be trusts underneath a will, so contained within the will.
Okay.
And so that's going to have more details, but all in all, your will, they're similar, but they can vary.
Okay. I'm glad you mentioned that, because I've heard the word trust as well too, and like my mom has a living trust.
Sure.
So and I don't really completely understand what all goes into that. So what is a living trust versus a will?
Sure. So a living trust is going to be an entity that you can start putting assets into during your lifetime.
Okay.
So your will does not mean anything until you die. You can change your will as often as you like. You can change your trust as often as you like. Like your trust, you can title assets into your trust during your lifetime. So if you buy real estate, you can title the real estate into the trust. You can have a bank account, investment account that the trust is the owner.
Gotcha.
Now, I kind of mentioned before that your will can have trust. You can have a trust under a will, which means your will, that document sets up trusts, but those trusts would not come into play until you pass away. Versus a living trust, which is kind of a living, breathing entity now.
Gotcha.
I like to think of it's kind of like a box, and you can start filling up.
Okay. Yeah, that kind of ties into my next question. So there are some benefits to having a trust versus a will, and you can indeed have both at the same time.
Yes. So if you have a living trust, you're still going to have a will.
Okay.
And it's going to be different than if you're just looking at an estate plan with just a will. But if you have a living trust, your will is going to be called a pour-over will. And what that pour-over will is going to say, anything I own at my death that is not currently titled in the trust goes to the trust. So it's pouring over into the trust.
Okay.
So some benefits of a living trust versus a will is you don't have to go through the probate process, which we can get into. And that's a big draw for a lot of people, that it's you skip that court supervised process when somebody dies. So that's a huge draw. Another draw is that a trust is more private. So when you if you have a will and you die and your will is recorded, that's public record. Anybody can access that. With the trust, it's not recorded in that way. That's why as celebrities and for other reasons, they don't want everyone knowing their business.
Of course.
But those are the kind of big draws with the trust. The non-probate is a huge.
Okay. Yeah, so talking about that, so if I have a living trust or a will and I then pass away, what kind of happens after that?
Sure. So when someone passes away in West Virginia, you have to go through the probate process, and pretty much every state you have to go through that. But in West Virginia, it kind of looks like you take their will, you take their death certificate, and you have to, there's some other paperwork involved, but you take that to the fiduciary office in the county where the person resided. So if you're a Berkeley County resident, you go to the Berkeley County office, and you have to qualify as their executor. And so your will is going to have named who you want to be the executor.
Okay.
So once you have someone that qualifies in that role, then that person is in charge of kind of gathering all the assets and all the information of what your estate is. And so your estate is any of the assets that you own, probate or non-probate. And so then what they have to do is they have to look at and fill out an appraisement form, which is basically an inventory.
Gotcha.
All of your assets, and they have to list it, and that gets filed. Then that starts a 60-day creditor period. So then creditors are able to put claims in against your estate. If there's no creditors, then it's a pretty easy finish, and the assets can get distributed after a little bit more paperwork. If there's creditor claims, then you have to look at, is there money to pay these claims, and have to deal with that. So it can take a while. So even the best can take a few months, and the worst can take a few years.
Wow.
So it just kind of depends on the situation. And so some people want, and there's fees associated with that too. So that's why some people.
So even after you pass away, you still owe people money?
It's expensive to do that.
Jeez. So if I actually don't have a will or a trust or anything like that in place and pass away, what can happen then?
So kind of the same thing would happen. You still have to go, someone still needs to go to the fiduciary office and file your death certificate. And there's other paperwork involved with it being, it's called dying intestate.
Okay.
So what happens is, because you didn't state how you want your assets to go in a will, the intestacy statute will apply. And so that's going to direct where these assets are going to go. So instead of someone becoming your executor, they become your administrator. It's the similar role, just different terms. But the thing is, that person's going to have to go get bonded, which is another expense. So you can usually waive bond in a will, and most wills will do that because they don't want to put that burden on that person. But if you don't die with the will, then that's like another step. And then the process is based more or less the same after that.
Is there a way, if you don't have a will or a trust or anything in place, can your county or your state take your assets?
The statute eventually leads there, but you have to go through a lot of relatives. That some people have a lot of relatives and some people don't. So basically what you look at is if you have a spouse, then generally it goes to the spouse, but that can change depending on if you have children. If either of you have children outside of the relationship, then the percentages change. If you don't have a spouse, then you kind of look down your bloodline and to see if you have children or grandchildren. If you don't have children or grandchildren, it goes up to the parents, grandparents, and eventually it can filter off to aunts and uncles and down to cousins. And then if you're still not hitting anybody at that point, then that's when it would go back to the state. So a lot of people are worried about that. It's kind of depending on how big your family is.
Gotcha. So that's like part of the probate process?
Yeah.
And that's one of the main reasons you would probably want to have a will or trust in places so your assets go where you want them to go.
And it's important because you've worked hard to get these assets, and so you want them to go where you want to go, and so you want to make sure your family is provided for. The will also, but not only in how the assets get distributed, a will is important because you get to pick who you want in control of those assets and handling those things until they get distributed to that person. And also, if you have children, you name your guardians for the minor children in the wills.
That's another good point.
That's huge.
So I heard when you talked about just a second ago about picking who you want in charge of your will or trust. I heard you say earlier about like an executor. Is there a certain number of executors? Like, can you have more than one executor?
You could have co-executors. In my practice, I don't like to name more than two executors because you're requiring these people to work together, and it can become difficult. But what we always do is you name an executor and you name at least one backup executor.
Gotcha.
So if that person can't serve, then you have a backup. If you don't know what's going to happen in life, then the person you name as executor might pass away with you or before you, and you have that opportunity to have someone step into that role.
Smart. Is there a minimum amount of money or assets that you need to have to create a trust or will?
There's not like a legally required minimum. If you're not super high asset, it probably doesn't make sense to do a trust, but that's not to say there's not a reason to not do it. And that's where your individual situation needs to be looked at.
Okay.
Most 18-year-olds are probably okay without doing a trust, or a will. But if you have assets that you want to go to certain people, then you should direct that.
Okay. So the minimum age is 18, right? When would you recommend that somebody needs to set up a will or a trust? Because a lot of people think like even myself, like I'll be honest, I'm 31. I don't have a will. I don't have a trust, and I thought about it the other day.
You need to get something.
Exactly, and that's why and that's why I wanted to talk
to get that together.
Yeah, so.
I'm not married. I don't have children, but I have my stuff in place. But I also can do it myself.
Of course. So yeah, like when would you recommend? Like, is there like a time period in your life or an age that you're like, okay, I need to get this?
Well, I don't think there's a one size fits all for everyone. I think like if you're young and you're starting out and you're building your estate, you're building your assets, I think once you get to a point where you feel like this is important and I want to it's to pass. If you have real estate, if you have money sitting in the bank account, like you would have a will so that you can say where you want that to go. This is your opportunity to say, because if you don't say, then the statute's gonna tell you. But other than it's kind of starting out, like there's life events that you should think about starting your estate plan, and if you've started it, revisiting it. So I would say if you're about to get married or you just got married, that's a good time to look at it. If you're about to have children or you have children and you haven't done it, that's something. If you lose a child, that's a time to look at that estate plan. As if someone that you've named in a will has passed away, then you might want to revisit it. If you get divorced, you want to revisit it. So kind of these bigger life events that happen. If you come into a large sum of money, you want to probably revisit your plan and probably also talk to a financial advisor.
Right.
And then if none of those life triggering events are happening, and you create a will, I would say kind of every 5 years, you want to just go in for a tune-up. You go to the doctor for checkups. You have your car, go in for tune-ups. It's not going to hurt to go in and look at your estate plan. You pay a consult fee, I'm sure, but but it's that sense of security that you're where you should be.
Gotcha. All right, so Jamie's called me out. I'm married and have 2 kids. I need to get my life together. So we'll be calling you after this. Are there any type of special provisions that I can add into my will that can protect what my beneficiaries get?
Sure. So you can do this. You can do this in a will. You can also do it in a trust. You have a lot of flexibility with how you want your assets distributed. So you can give your assets to your beneficiaries outright, which means if they're held in trust, then they just are distributed to that person and the trust will terminate at that point. If you're going through probate, that means when it gets to the point of distributing out the assets, they give it to you in trust. So if I leave you $50,000, then my executor just gives you $50,000.
Okay.
That's kind of it's not what's in there. But and so that's kind of the most straightforward route. You can then add in restrictions or guidelines for how you want that to be distributed. So you have young children. You probably wouldn't want them, if something happened to you and your wife, you wouldn't want them to get that money outright.
Right.
Because they're young.
Right.
So you can say they don't get that money until they're 25, or you can break it down and say they start getting at 25, then 30. You can say half now and half later, or you can do X amount a year.
Okay.
You can do percentages a year. And that's not to say that, if they're 5 years old, that they have to wait 20 years for that money to be used.
Right.
Money can be used for their benefit, but they're just not given it access to it. So they have to go to the control to say, hey, I have this great I need a car, or I want to go to school.
Okay. So who is the trustee?
You get to pick that person.
Okay.
So sometimes it's the same person as your executor. Sometimes it's the same person as a guardian for a minor child.
Gotcha.
Some people like the checks and balances approach of naming one person as guardian and another person as trustee.
Okay.
You kind of have to think about who you're naming in these roles and if they're going to work together.
Gotcha.
Some people name banks will serve as trustees. And sometimes attorneys will.
Okay.
But and that's something that we talk about. And if the thing with banks and attorneys are going to charge you versus your family member, they still can get a fee, but it depends.
I got you.
The benefit of banks and attorneys is that this is what they do.
That's what they do.
And so sometimes that is more beneficial.
Okay. So what is a power of attorney? And if I'm creating a will or a trust, do I need to worry about that?
I say yes. A durable power of attorney, which is known as a financial power of attorney, I think is one of the most important documents you can have. You don't have to create them all at the same time, but the thing with your will is going to handle how things get distributed once you die.
Okay.
Your financial power of attorney, the durable power of attorney, that is taking care of your finances now. So what that is this is a document where you appoint who you want to have control of your finances. And so there's different versions of a power of attorney. So there's a version that when you sign it, it's effective immediately. So the person that you name in that document can take it and access your bank accounts and do real estate transactions on your account and change beneficiaries depending on if the document gives that type of power. So you could be giving someone a lot of access to your finances. The other version you can do is called a springing power of attorney, and so it does not spring into action until a physician deems you to be incapacitated.
Gotcha. Okay.
And there's different reasons why you would choose one over the other, and that's something that you would talk about with your attorney. But regardless of which one you decide, it's extremely important because you have to have legal capacity to sign this document. So you can't wait until you might need it.
Right.
Because you might not have capacity. And so we look at people as they get older and you develop dementia and Alzheimer's, but even like younger people, you don't know what's going to happen. You could be in a car accident and have a traumatic brain injury that leaves you unable to make these decisions. Your power of attorney would kick in and be able to handle your finances.
Gotcha. Yeah, that's one of the main reasons when I first, got back with you and talked to you, because whenever I go to the doctor, and I've had several surgeries, probably more than several if you know me, but every time you go in, they're like, do you have a will? And I'm like, no.
Yes.
So,
they're
I'm like, yeah, they just well, I'm not gonna would, but so definitely, my wife and I definitely
and
deal with you.
Definitely. And the financial power of attorney, that's one power of attorney you can have, and then you could also have a medical power of attorney. And so they can be different people. A lot of times they're the same person for people, but your medical power of attorney is who would make medical decisions for you if you couldn't make them for yourself.
Gotcha.
Well, one other thing I will kind of say about the financial power of attorney, so our office, we're estate planning attorneys, but we also are elder law attorneys. And so when we look at that, we're looking at if you or your loved one had to go into a nursing home, what do you have the documents in place where we can help you protect your assets? And so that financial power of attorney is going to be what helps us protect your assets so that they're not getting paid out to the nurse, because there's other strategies and alternatives out there.
Good to know. So if I'm a beneficiary or somebody that is receiving an inheritance, is there anything that I can do to protect myself, or is there any type of planning I should do before I accept or receive anything?
You know, if the person that you're a beneficiary under their will hasn't died yet,
Okay.
I would say don't count your chickens before they hatch, because they could change their will at any time.
Right, of course.
So if the person has died and it's become apparent that you're going to inherit some assets or money from their estate, then I think definitely talk to an estate planning attorney and a financial advisor to see what is the best way for you to accept these assets.
Gotcha. Okay. Well, thank you, Jamie. This has been definitely very helpful. A lot of knowledge passed through here, because this is something like I said, especially in our generation, you know, we're all becoming older adults, parents, stuff happening. And I think this is something good that, you know, the community needs to know about, that we can share and maybe start getting people to get their assets in order.
Yes.
For sure.
I don't think it's ever too early.
Yeah.
Like, if you're worried about whether you should or shouldn't, go ahead and do it. It's not going to be a problem for
Okay.
you to go ahead and do it.
So if I'm watching this now and I'm thinking, you know, man, I don't have, you know, these kind of things in order, how can I contact you? Where's your office?
Yeah.
How can I go about it?
Yeah, so our office is located at 299 Rockcliffe Drive, so we're in Martinsburg. If you're a resident of West Virginia, we can help you. Our phone number is 304-263-9099. And that's the best way to contact us. Give us a call and schedule a consult appointment, and then we can talk about what your individual plan looks like.
Perfect. Well, that's Jamie Hill. Ladies and gentlemen, feel free to reach out to her in her office if you guys have any questions regarding wills and estate planning. And as always, you can reach out to me at 304-839-7040 if you have any real estate questions. Thanks. Stay up and stay blessed. Peace.